Surviving the Survivor. We bring you the best guests in all of true crime. Don't forget to subscribe and smash that like button. Here's your host, Emmy Award-winning broadcaster, Joel Waldman.
What's up, STS Nation? Welcome to Surviving the Survivor. It is the show that brings you the very best guests in all of true crime on trending criminal cases. This has been in the news for the better part of 4 or 5 years. Lori Vallow making headlines when it should be this guy, Charles Vallow. And I see Julie Frew saying we are live, and we are, in fact, live. There was some confusion today about what was going on, and the people confused were myself and the COE and a lot of others. We're hearing from some people, no stream today, others possibly a stream today, others perhaps there's a stream today, and turns out this is now according to a source that I think we all trust on this story, Nate Eaton. Shout out to East Idaho News. He has posted that it will be streamed starting any moment, and I've got an eye. I'm watching Space Coast work his magic behind the scenes, trying to get the pool camera to us. Again, you are looking right now at 3 different pictures of the handsome Charles Vallow, no longer with us, although he should be. He was Lori Vallow's 4th husband. Lori and Chad, and I guess Alex, considered him to be quote unquote dark. And this entire trial is trying to for the government to show a conspiracy here between Alex Cox, who's also no longer with us. By the way, I got an interesting email today from a physician who told me a lot of Alex Cox's symptoms, or the things that I guess were described post-death, could also be very symptomatic of organ poisoning. As we know by now, Lori, unlike what is usually done in the LDS Church, had him cremated, shockingly. So there's not much to go on. Lori Hellis yesterday did, in fact, talk about, and I need to message Lori, but Lori Hellis did talk about how the Emmys usually hold on to some kind of tissue in case there's a potential investigation that needs to be done down the road, which could happen here. So as far as today goes, and look, I got some people yesterday saying, hey, this guy looks a little distracted. I'm not distracted. I work on this stuff full time. I'm just usually doing multiple things at once. So I'm just trying to clear the air on that, because I would hate to go on a Joel rant on a Thursday when I'm just calming down. Could be poisoning by milkshake, Vesper Martini. This is, I mean, the implication from this doctor is that she thinks that far too many people in this family died far too young under somewhat mysterious circumstances. That's the implication. She doesn't have this specific evidence, but she's a medical doctor who practiced in medical school to get where she is. And so just sharing that with all of you. The other big thing to thank you, Purple Coconut. I do appreciate this. Horrible, malicious, horrendous accusations levied against me. On the other channel right now, not that I don't want you to stick around here, you've got Kelsey Kernstein, who's a friend of the COE's, who's also a former broadcast news person, and she's actually interviewing Dr. Ann Burgess as we speak on the other channel about the Menendez brothers. She, Ann Burgess, of course, yeah, someone's saying Joe Ryan too. But where was I headed? I hope I don't have early dementia, because I have like short-term memory screw-ups, but I guess only time will tell. And my mom might even say it's not early dementia, it's just dementia. There's nothing early about it. But I hope it's not true, because that would really not be good. And I wouldn't even know. Mr. Man, I like the name. I like the name a lot. Joel, look at you multitasking. How ironic would it be if Mr. Man was actually a woman behind that screen name? Who knows? She is a serial killer. For a minute, I thought you were talking about Ann Burgess, and I was ready to throw down Mary, but I understand now. We were talking about Lori Vallow. Francois Gal or Gal. I love that name. Let me know, Francois, if you're from France, or perhaps Canada to our north. See Neely in the chat, Carrie Lassiter, Sweet and Salty. No, it's called being a parent. Guaranteed to scramble your brain. Yes, that is true. I got a call. I have a soon-to-be 11-year-old daughter going on 18. I get a call from her. They're off of school this week for the Easter/Passover break. And I get a call from her. She's at a sleepover at 11:30 last night, 11:30 p.m. She's still up. I'm like, why are you up? Her friends are now on this call, and they are asking me, expressly asking me, not their mother, but me, to drive them to Ulta today, which I guess is like a makeup store, sort of like a Sephora. I have no idea. Francois is French. Love the name. So I said, I host a podcast, and I work and I try to feed you, put food on the table, have a roof over your head. And they had no idea what I was talking about. All they wanted to do was go to Ulta. And yes, this is that's where I'm getting to that in one moment. Anyway, long story short, I told him no way. Normally I would, but not on a quote unquote work day. Not when they're calling me at 11:30. And this is just a harbinger of things to come. The ladies are now sunning themselves in South Florida out back. Rough life for these kids. Very, very rough life. On a serious note, there is an active shooter situation that happened on the Florida State University campus, of all places. That just happened in the last few hours. I think 6 are reportedly shot. 2 have died. They believe they have the shooter in custody. And we're monitoring that. Tim Jansen actually flagged me on this a while ago. And I've been another shooter. Welcome to America. Welcome to the United States of America, where there's, if it is Thursday, there's an active shooter on campus. It is hot today. My man Myron, Miami Myron Sanchez. It is hot today. So we're monitoring this shooting. It looks to be somewhat contained. 2 people lost loved ones today, I believe, if those numbers are accurate. Probably for absolutely no reason other than just an other shooter on a college campus in America. But it is particularly close to home since Dan Markell, the former FSU law professor, is our original OG story. And then you look here for Misbehaving. Cable car, just to add to the tragedy of the day, a cable car has crashed in Naples, Italy, 4 unalive. Horrible, horrible. I hope, Joe Petito is not in Naples as far as I know. Joel, I just hopped on and I work at FSU. Glad to see you reporting on it. April, let us know if you know the latest numbers, and I'll check on this. Just to kind of round out what I was saying at the onset. So we've got, allegedly, we have Lori Vallow's hearing today. And this is the sentencing, the jury instruction, the hearing about jury instructions. So it's not jury instructions, not actually delivering the instructions to the jurors, but they are going to be arguing over the jury instructions. Perhaps not the most exciting thing in the world, but we are all one big happy family here at STS, and we've covered days 1 through 7, so why not do day 8 together? Again, it is supposed to have started 9 minutes ago. I see Space Coast still monitoring the activity on in the court backstage. So we will. Neil Campbell says, this does not surprise me at all. There are 120 firearms in this country for every 100 American residents. Now, someone is going to yell at me for being political, even though this is what is supposed to be a factual statement. April letting me know here. Sorry, wrong person. 2 dead, 6 injured. Rumor is potential. That would be wild. That would be perhaps worth talking about some more if this is in fact the case. And are all 3 in custody? I don't know. I don't think I've ever heard. We know Dylan Klebold, and I'm blanking on the other kid's name from Columbine, but I've never heard of 3 shooters that I'm aware of at a school shooting. I don't know. That's obviously not confirmed yet. Not that I'm questioning April, but these things always change at the onset. Miami Myron Sanchez says best panels guaranteed. That is true. I don't want to, sound immodest about my own channel, but it is true. Look, Carrie says facts, Joe. I have no idea if that's related to this, but it fit. Were JJ's crushed up meds mentioned during testimony? I don't recall that. If anyone here recall, I don't think so, because I don't even think they were supposed to be discussing that. Mim Benjamin is here from Jerusalem, Israel. You may have heard of Jerusalem, Israel, a pretty historic place, somewhat famous. Finland is in the house. I love that. A guy with ADHD, it takes me a while to get around to what I was saying. 2 o'clock, again, 11 minutes ago, this was supposed to start. We'll be on it when it does. The other huge story of the day, the Menendez brothers. They are supposed to have a hearing, a 2-day hearing beginning today about resentencing them, if it will happen. The basic 2 potential outcomes are they are not resentenced and everything stays as is, or they could be resentenced, very likely to life in prison as opposed to life without parole, which is what they have now. And that would kind of open the door to them being released. A lot of people think sooner than later. Julie Frew is saying the stream is not starting later. 1 shooter confirmed in custody. COE, if you're here, can you let me know what you're hearing about the stream? It should have, I believe it should have started then. I know Space Coast is looking for it, and he'll find it wherever it is. I'm just taking a peek at that now. So again, the other big story, the Menendez brothers, they are going to have people from the prison, kind of character witnesses, to speak about Lyle and Eric today, and make the case for why they should have their sentence switched from life without parole likely to just life. However, DA Nathan Hochman, who is the new tough on crime DA in Los Angeles, who is opposed to this resentencing motion and argued against it, even though a judge overruled what he wanted. Nathan Hochman is now asking for a delay in this hearing, which could happen. They're hearing about the delay right off the top. What time is it here? It's about 11:15 a.m. in LA. So not sure exactly. Julie Frew is letting us know court started late today, Joel. So that's why we're just not seeing it yet. Thank you, Julie. Julie, do we happen to know how late it started today? Let me see. I thought she was going to answer, and then I realized she's in the chat, not talking to me. Joel, I'm a few minutes behind. I'm telling you, cherish everything with your daughter. These times will be gone before you blink. I know. It's actually sad. I'm already getting upset about it. It is flying by. Stream starts at 2:15 my time. That is in about a minute's time. We're going to go to it live when this happens. Oh, look, Space Ghost, I'm glad the COE tells you, but tells me nothing. That's usually how it goes. And that is it. Tomorrow, by the way, I do believe we are going to pick up the second half of the Stefan Stearns police interview with veteran homicide detectives Phil Ramos and Dr. Detective Troy Looney. So that should happen tomorrow at 12 noon. Oh, look who's stopping by. Hello, COE. Apparently you've got the word on when this is actually starting. You just failed to mention it to me. That's okay. Nothing to worry about. No apologies necessary. She just took herself off. COE, do we know what time this is starting?
People in chat are saying noise in the courtroom, but
What? Say it again.
Hi, I'm sorry. I was on our other channel, STS Talk. Please check it out. 10:45 is when they were starting, plus the delay. So we should be hopping on any minute now.
10:45. Okay, I can't do the math anymore.
Yeah, but no, I purposefully gave you a 15-minute buffer.
Hey, COE, the chat, the best community in all the land, letting us know that the shelter in place is still going on at FSU, and there are some reports of multiple shooters. So if you can kind of keep an ear open to that, that would be great. Look at this, Newfoundland, our neighbors to the north. They had an extra half hour added. That's interesting. Who knew that Newfoundland has an extra half hour added to their time zone? That's I never knew that till this very moment. So there you go. COE, you're here. I guess there's not much else to say. I think you guys all know that the state rested, then the defense rested, but Lori had
Did you get
a little
the state's email this morning?
We did. That's what
I have a couple revisions based on what they said, but also one thing I need you guys to address is I did 404.
Here we go.
4.04, the justification, self-defense instruction, and on looking through the instructions again, I don't know if 4.05 is more appropriate because that's the one that deals with deadly physical force.
It would be.
So why don't you guys talk about that? And yeah, I'll give you a few more minutes. We can, yeah, we're off the record.
I just also emailed Lori Hellis, the good Lori, to let her know that we're on in case she wants to join in the festivities here. Susie Q says Lori is toast. While we're waiting, why don't we do this? How about AJA? Ask Joel anything. I don't know that I'll be able to answer it all, but how about that? How about we start there? The judge is quite a few people commenting about the judge and saying he's a handsome, dapper young man. I would have to concur, but yeah. I was saying right before the court started up that, and we do know that court has started. North Carolina horse lover. She's been part of the chat for a long time. Raquel Acevedo, who I think is forgetting an L on her name, unless I've always thought it was Raquel, but it's really just Raquel. Is that possible? It is definitely possible. Do you feel the prosecution met its burden? Good question, and I appreciate the question. I think that this final witness, Detective Duncan, who is the lead investigator, I think he tied things up. There's just too many connections via text and phone calls and the timing of it all. I think this is going to be a quick deliberation, and Lori is going right back from whence she came. I mean, the only kind of, it's interesting. I was, I don't want to bore you with my personal stories, but I was getting a little therapy on the neck today. And the therapist, who's a very smart guy, happened to go to an Ivy League university, was asking me, why are they, quote unquote, wasting money on this trial if she's already convicted? And I explained that it's all about justice for this family. And it's interesting because I think people who don't follow true crime quite as closely, they don't really realize this, they don't know. Someone asked me who I think is going to win the World Series. Without a doubt, the New York Yankees. However, Space Coast would likely disagree. Becky Ireland, when are you ever going to say "Love You, Ohio"? I got to get that in there. Ohio, Ohio. Who's the most famous person in your phone? These are good questions. I do have some famous people in my phone. I don't know the most famous. Let me think about that. But I do have some people that you would know of in the phone who I don't necessarily call. I just happen to have their number. I also have a very good friend who used to work for Major League Baseball. He was a journalist for MLB, and he has every single baseball player's phone number. And so there was a time where, I don't know, I snatched a couple of those numbers just because I thought it was funny. They got some famous baseball players in there. I don't know the answer to this. Does anyone know the answer to this? Will it be the same judge for Brandon Boudreaux? I think we get like a week off, and then this happens again, which sounds kind of crazy, but I guess this is interesting. I just saw this late last night. Thank you for this, interested watcher. Again, our OG case is about FSU law professor Dan Markel, murdered in his driveway back in July of 2014, and 2 hitmen were eventually caught, and a middle woman connected to the ex-wife's family. Donna is the ex-mother-in-law. She's going on trial June 3rd. I'm going to be in Tallahassee. It wasn't that long ago that I was at the Student Center at FSU. So to hear about this shooting today is pretty scary. Could have been anybody in there. But there was a motion apparently filed to get rid of Judge Everett, which failed. I think it was, I don't know what that is other than a stupid move. I would have to ask a lawyer to be certain, but I'm not sure what the grounds were for that. But I'm sure Judge Everett wasn't too thrilled to find out that her defense team was trying to get rid of him. So I don't know how smart a move that was ahead of the trial. Hi, Joel. Nate Eaton says the judge was very trendy too. Look at this. Penny B with the breaking news on the judge. Judge is very trendy. He saw him without his robe going to court. He's really good. So very patient with Lori one. Happy Easter from Scotland. So he is trendy as well. He's got like a designer suit under there. Who knew? This would be true. Lindsay Gandy is probably the most famous person in my phone. If you want to meet famous people, you got to hang out with Lindsay Gandy. Do you think Lori is going to be acquitted? I don't. I really don't. Do I root for the Heat? I'm a longtime New York Knicks fan. The truth is, as I've gotten older, I love sports. I enjoy sports. I will watch I love like the baseball playoffs. Something about the NBA, I'm just not into the NBA anymore. I don't know. I grew up when it was the Lakers. Yeah, you can watch the show here. Ann Burgess just wrapped up a show. I absolutely loved the NBA when I was younger, but I grew up like in the golden age of basketball with the Boston Celtics rivalry against the Los Angeles Lakers. By the way, Space Coast would say the Dodgers are going to win the World Series, and that is likely very true. They might win it for the next 10 years in a row. Who here is planning to go to the Los Angeles Olympics? That's something I really want to do, especially now that my daughter is obsessed with gymnastics. Have I ever met Carly Simon? These are some of the most random questions in the history of the world. Justice for Dan Markel. Have I ever met Carly Simon? No, but I did find out she's connected to the publisher, Simon and Schuster. I have my Rolodex, my dad's Rolodex from 1954 to 1974 with Frank Sinatra, Dean. Wow, what did your father do, Mary Kolovich? I would like to know. What did your father do? That's a very cool thing. We should call Frank Sinatra's number live on the show, see what happens. It'd be wild if he answered. I don't think that's going to happen. Fred is out back suntanning with the girls. Have I ever written a book? I have written a book. Same title as the podcast, Surviving the Survivor. It will change how you see life. It's my mother's story of survival during the Holocaust. CJ, you need to email me immediately. survivingthesurvivor@gmail.com. The COE's family, including Space Coast, are all from LA, and I'm planning to go. And if you're being serious, I will do whatever it takes to butter you up because I really want to go. Boho Hobo, how are you? Here comes Lori sitting down. CrimeCon, we have submitted everything we need to go. We just haven't heard from them. So if you want to annoy CrimeCon and say, hey, our favorite podcasters have not heard yet what is going on, feel free to do that. Just don't tell them I told you to do that. I cannot believe I'm on the LA 28 committee from CJ. That's wild. Ned Smith letting me know that Carly Simon's dad was Richard Simon. Perhaps he went by Dick Simon, but that is Simon Schuster's daughter. That probably helps a little bit.
All right. We're on the record in CR 2021-001704, State of Arizona versus Vallow Daybell.
On the record.
State is present. The defense is present. The jury is not present. This is the time set to discuss the final jury instructions. Let me confirm with the defendant that is it still your intention to not put on any evidence?
Right now, Your Honor, yes. As of this morning, I mean.
Well, do you anticipate that changing?
No.
All right. Because
definitely changing.
These instructions will be read to the jury. So for now, we're assuming you're not putting on any evidence. Let's just go through page by page. I think it's probably the easiest way to do it. On the cover page, I did correct. I had 2001 instead of 2021, and I corrected the case number. The first instruction on the top page 2, duty of jury evidence to be considered and rulings of the court. These are standard instructions in Arizona. I'm assuming there's no objection to those from the state,
No objection.
from the defense.
On page 2?
Yes.
No objection.
All right. Then on page 3, I did remove the stipulations because I don't think there were any stipulations. So on page 3, direct and circumstantial evidence, production of witnesses and evidence, redacted exhibits, those are standard. Any objection to those from the state?
Your Honor, I did object to the production of witness and evidence. I
want to hear about that because that's a standard given when we have a situation where we've heard about people like JJ, Tylee, Alex Cox. We've heard about Summer. We've heard about Detective Moffat. None of those people were called at trial. So I think this instruction simply says that neither side is required to call, basically everyone that's mentioned in the evidence.
guess as long as the defendant is okay with it. Obviously, I've not seen that previously included in an instruction. My concern was the burden shifting potentially, saying that neither side is required. And that seems to imply or in opposition of the fact that the defendant need not present anyone anyways, ever. That's my concern with that instruction.
All right. Before we talk about that one, let me hear from the defendant. Any objection to the direct and circumstantial evidence and then the redacted exhibits on that page?
No, those are fine. Your
Okay,
Honor.
what are your thoughts on the production of witnesses and evidence?
I tend to agree with the prosecutor, but
That it shouldn't be in there?
correct.
Well, if the parties are stipulating that it's not in there, I'll remove it. Is that the case?
I believe so, Your Honor.
Yes, Your Honor.
All right, by the stipulation of the parties, I'll remove that instruction. I probably should have brought my hard copy because you guys are working off a hard copy on my computer. This is kind of maybe paginate different. So now my next ones are indictment is not evidence, self-represented defendant. Any objection to those from the state,
No, Your Honor.
from the defense?
No.
All right, then on the comments are not evidence. The reason I highlighted that is it was to alert everyone that I did change the language in that a little bit because the defendant's self-represented. It mirrors what I did in the opening, what I read to the jury before opening statements, more or less, in changing it from the attorneys to the prosecutor and the defendant talk to you about the law and the evidence. Are there any objections to that instruction from the state,
Not as changed, no, Your Honor.
from the defendant?
No, it's good.
All right, then we have credibility of witnesses, and on my page 4 is testimony of law enforcement officers, but that might be on your page 5. Any objection to those two from the state
No, Your Honor.
defense?
No objection to the ones that are in there.
All right, then we have expert witness. Any objection to that from the state,
No, Your Honor.
from the defense?
Nope.
All right, based on the defendant's indication that she's not going to be presenting evidence, I would remove defendant's testimony. I would keep in defendant need not testify, and I would remove defendant witness prior conviction if that remains the case. So any objection to that from the state,
No, Your Honor.
from the defendant?
Nope. No objection.
All right.
Can we add in there something?
What's
Is this the
that?
time to ask to add something in there?
Go ahead.
The standard 19, the defendant statement voluntary.
Voluntariness of defendant statements.
Mhm.
That probably should be in there. What's the state's position?
No objection.
I will add that. I'll add that right after defendant need not testify. Just making a note. All right, then we have jury not to consider penalty. Any objection to that from the state
No.
defense?
Nope.
All right, the state emailed this morning. I think the state wants the alternative presumption of innocence, burden of proof in the Rajis. Is that correct?
Correct, Your Honor.
You want to make a record on that?
Your Honor, the current version the court has in here discusses the various levels of the burden of proof for preponderance and clear and convincing, which are not relevant to this. Case law is very clear under Portillo that the court is only required to present the Portillo instruction, which is partially on the next page in my hard copy, which explains to the jury the burden of proof for a criminal case. I think that going through other levels of burdens of proof without understanding or being provided context for that is confusing to the jury, is not necessary, and Portillo does not require it. So we're requesting the court just provide what has been mandated, which is the Portillo instruction.
What's the defendant's position?
We agree. It's confusing.
Okay. So I think that's just the last two paragraphs, right?
Yeah, from the three standards through the preponderance and the clear and convincing. So it would still have, the presumption of innocence, and then it would go to the beyond a reasonable doubts portion.
Okay, I will, by stipulation of the parties, change that instruction. So it'll read, the law does not require a defendant to prove innocence. Every defendant is presumed by law to be innocent. You must start with the presumption that the defendant is innocent. Then I delete until the last two paragraphs. So then it will read, the state has the burden of proving the defendant guilty beyond a reasonable doubt. The rest of that paragraph. And then the next paragraph, proof beyond a reasonable doubt is proof that leaves you firmly convinced. And that entire paragraph, is that the agreement?
Yes, Your Honor.
Yes.
Okay. So my pages are not going to be the same as yours at this point. So we'll just go through it a couple at a time. Evidence of any kind, voluntary act, and then absence of other participant. Any objection to those three from the state?
Yes, Your Honor. And the evidence of any kind, I had sent in my email that we should remove acting with the advice of an attorney. The defendant is her own attorney, so she is, I think it should just be a period after evidence is left to the defendant, period.
You're right. I will remove that sentence. So what I would propose is it would read as follows. The state must prove guilt beyond a reasonable doubt based on the evidence. The defendant is not required to produce evidence of any kind. The defendant's decision not to produce any evidence is not evidence of guilt. Is that what the state requests?
I would have left the decision on whether to produce any evidence is left to the defendant, period. And then the next sentence, cutting out acting with the advice of an attorney, and then have the last complete sentence as well.
I don't have a problem with that. What's the defendant's position?
I agree.
You agree with the state's
Yeah, I
wording?
agree with, yes, just to cut that part of the sentence off.
Okay. I already deleted it, so read it back to me, state, please.
Sure. So the state must prove guilt beyond a reasonable doubt based on the evidence. The defendant is not required to produce evidence of any kind. The decision on whether to produce any evidence is left to the defendant, period. Then the defendant's decision not to produce any evidence is not evidence of guilt.
So the decision on whether to produce any evidence is left to the defendant. Okay, when we're done, we're going to print out another copy and make sure everyone's on the same page. All right, let me turn to the defendant. We've addressed evidence of any kind. Any objection to voluntary act and absence of other participant?
No objection.
All right, then we have motive. Any objection to that from the state?
We did have flight or concealment in the ones that we
I'm
have.
sorry, you're right. I should have stated I did delete flight or
Okay.
concealment. I don't think it's applicable in this particular set of circumstances. So then we just have motive.
No objection to motive, Your Honor.
And from the defendant?
Yeah, no objection to motive. No objection.
All right, here's where mine's going to change a little bit. I did the charged offense, each instance where it says first degree murder, where it used the numerical first, I changed to a capital spelled out the word first in that, and then in the definition of first degree premeditated murder. And the reason I highlighted in here, there's a couple highlights, a person, and under premeditation, she or a co-conspirator. Those are changes I made to the standard because the standard just says defendant. So let's just talk about the charged offense, the definition of conspiracy, the definition of first degree premeditated murder, and then the definition of premeditation. Any objection to those with the changes that I've stated from the state?
No, Your Honor.
From the defendant?
No objection to that.
All right, then where it's altered a little bit, so there was an accomplice based on liability, based on the result of the crime that I had here. I've deleted that and instead put accomplice, the traditional definition of accomplice, in the definitions section. And I think what I'm going to have to do is we're going to print out a fresh copy and give it to you guys when we get there. And what I've inserted here is elements of a conspiracy, scope of proof of conspiracy, proof of membership in conspiracy, which in my original draft only had the scope, I think, of proof of conspiracy in a different spot.
Correct.
But does the defendant need those printed out to review? Because I have
I was
changed.
going to ask for those to be added, so I did
Okay.
review them with my advisory council.
All right, I want to make sure though that you are literally on the same page with what's going to be read.
Yeah,
So,
I would like them to be printed so I can see them.
all right. We'll come back to that when we get you a hard copy. What I wanted to ask the parties was I initially included the Raji 4.04 for self-defense justification. But in a second look this morning, I think 4.05, which is justification, self-defense, physical force, and it specifically talks more about threatening or using deadly physical force, I think is more applicable. So what's the state's position on that, inserting 4.05 in place of 4.04?
I would agree, Your Honor. This relies mostly on physical force. Obviously, we're discussing deadly physical force here. So otherwise, the jury has to try to implant deadly physical force throughout this entire instruction.
And I think they should both be in, but
Well, while we're on the subject, are you requesting any other justification instructions?
well, I was going to ask for that for 2.04A.
For what?
The 2.04A, 2.0401A.
What's that? I don't have them all memorized.
Oh, the Arizona 13204.
Is that a Raji you're referencing or a?
Yes.
Hold on, let me bring them up. What's it called?
It's the Cashion. Is that what that is?
So.
I was on the wrong one. So we are going to be asking for those, but
I don't think I'm clear on what you're asking for.
so we were going to ask for the 4.06, the defense of third person, the 4.07, defense of premises, the 4.11, crime prevention.
What was the crime that was being prevented?
The assault on myself, on my daughter, on my brother.
Defense of third person, defense of premises, and defense of or crime prevention.
Correct.
In addition to justification, deadly physical force.
Correct.
All right. Those get really convoluted and long, and there's a lot of repetitive information in those, but the case law says if there's even the slightest bit of evidence, then it's error for me to not give those. So what's the state's position?
Your Honor, I think understanding the case law, the defense of third party would be appropriate. The defense of premises.
I don't have it in front of me, but I think the defense of premises requires that the person be forcing in or trespassing
Correct,
on the
rather
property.
than being invited into the home. So I don't see that justification in defense of premises is appropriate, given the facts that we have here.
Let me look at it, because doesn't it also say or remain unlawfully if they were asked to leave?
I guess we have no, let's see.
There's no evidence of that specifically, but I guess it could be inferred, and I would hate to risk a reversal on something like that. So let me take a closer look at it.
I think the other question is on that, goes to then the lawful possession or control of the premises, given that Charles Vallow himself was paying for the premises, which we have admitted evidence of.
The evidence also admitted is that he flew into town and came over to that house, not living there at the time. So it does infer it as well.
Well, he's on the lease. That would seem to have some apparent authority to be there, but let me take a look at it.
It refers to criminal trespass, which I think the point here is you cannot be criminally trespassed off of your own property.
So I will give the 406, which is justification for defense of a third person. I'm not going to give justification in defense of premises. It requires that there be a criminal trespass. I think it's confusing to the jury also. If there's an argument that's made that he committed a criminal trespass because he was on the lease, he had authority to be there, and he was, even if he didn't have authority to be there, he was invited in to get his son.
In lieu of that, Your Honor, then we would ask to add 418, 4.19, defensive residential structure.
Record on 4.11, which is use of force in crime prevention.
Sorry, I was looking at 418 that defense just raised. Let me go back to 411. Trying to find 411, but my
So,
search is
uh,
not.
I'm going to hop back to 418. 418 is not applicable. 418 applies to home invasion type situations, and it talks about threatening or using deadly physical force. If the person against whom the physical force is threatened or used is in the process of unlawfully or forcefully entering or having unlawfully or forcefully entered a residential structure or occupied vehicle. So there's no indication that Charles forcefully entered the house. So I'm not inclined to give 418. Does the defense want to be heard further on that?
No, Your Honor.
And then was there another, you said after 418?
I just said 418 and 419. I guess that's the presumption of that.
Or, so 419. That's applied to the residential structure, so that one wouldn't be applicable if 418 is not applicable.
Okay.
So I'm not going to give 419. Did the state look at 411 yet?
Just found it, sorry. Your Honor, I think probably given Carson and the allegations that the victim used a bat, we would have to give that as well as then the instruction for the crime that they are indicating they believe Charles was committing, as is required per the
Right. So you agree that 411 needs to be given? So that's my reading as well. So I will give 411, just so we're clear, I'm removing 404 self-defense justification. I'm adding in 405 self-defense justification, deadly physical force. I'm going to add in 406 defense of a third person. I'm going to add in 411 crime prevention. Okay, I think that brings us to the definitions. I remove deadly weapon. I think I had it in there initially because I thought it was in the justification statute, but at closer read, it's not. So in the definitions that I have right now, I have intentionally with the intent to, and then intent may be inferred. Then I have knowingly, willfully, knew. And if the state is required to prove the defendant acted knowingly, that requirement is satisfied if the state proved the defendant acted intentionally. Then in the next paragraph, a defendant is criminally accountable for the conduct of another if the defendant is an accomplice of such other person in the commission of the offense, including any offense, and the rest of that paragraph. Any objection to those from the state?
No, Your Honor.
From the defense?
No, Your Honor.
And then here is where I've inserted the traditional definition of accomplice because I deleted the completed act definition of accomplice. So this says accomplice means a person who with the intent to promote or facilitate the commission of the offense does any of the following: 1, solicits or commands another person to commit the offense, or 2, aids, counsels, agrees to aid, or attempts to aid another person in planning or committing the offense, or 3, provides means or opportunity to another person to commit the offense. Any objection to that from the state?
No, Your Honor.
From the defense?
No, Your Honor.
Then I have a few more definitions: act, conduct, physical force, and a definition of deadly physical force. Any objection to those from the state?
You said something else I don't see in here, so sorry. Oh,
Act.
act was a previous page, sorry.
I kind of did it in alphabetical order. So accomplice went in, then act. So act, conduct, physical force, deadly physical force.
No objection.
From the defense?
No objection.
While we're in the definitions section, I'm going to have to look at when we're adding crime prevention and defense of a third party, whether there's any additional language in there that would require additional definitions. But other than that, are there any other definitions the state's requesting that I didn't include?
Other than, obviously, the state hasn't looked at either of those, either new instructions requested by the defense to see if there's additional information. So I would have to look at that prior to approving these.
Okay. But other than that, you don't have any that come to mind?
Not off the top of my head, Your Honor.
All right. How about from the defendant?
No, Your Honor.
So then the rest of this is pretty standard. It's the jury foreperson and the closing instruction. And then I have a form of verdict. Any corrections, objections to any of those from the state?
Just the form of verdict, changing the 1 ST as well to first degree.
Okay. There's no, we don't need any interrogatory on dangerous. It's automatic, right?
It would not be automatic.
It's
I don't
not.
believe so, because it does not require the use of a weapon. So we would actually need to have a penalty phase to
Okay,
have that
so
determination.
That would be done in the second phase, if there's a second phase.
Correct.
Okay. Let me turn to the defense. Those last, first of all, any other definitions that you think need to be included that I didn't include?
Hold on one second. Your Honor, we had missed one that we wanted added was mistake of fact, 205. I'm sorry, I don't want to backtrack.
The revised jury instructions from 2 years ago don't have a 205.
Sorry, it's 204. I apologize.
Causation, ignorance of fact. Is that what you're talking about?
Correct.
2.0401A. Ignorance or a mistaken belief as to a matter of fact does not relieve a person of criminal liability unless, one, the ignorance or a mistaken belief as to a matter of fact negates the culpable mental state required for a commission of the offense, or two, the ignorance or a mistaken belief as to the matter of fact establishes a defense of justification. So what's the mistake of fact that you think exists?
Your Honor, it's mostly the mistaken of fact that have been presented as evidence in this case, like one shot versus two shot. You were being attacked, you weren't being attacked. It's things that the state is proposing that I'm denying.
Well, you can deny those and you can argue that, but that's not really what is meant by a mistake of fact. It refers to a misunderstanding of the facts that would somehow negate any criminal liability. In other words, you'd have to be under a false belief about a fact. I think an example might be if someone's breaking into your home or someone's coming into your home, you thought it was a burglar and you shoot them and it turns out to be your spouse. That might be a mistake of fact. So a dispute as to what the facts are, what the facts mean, wouldn't warrant this instruction unless you have something else.
That was all. That was what I was thinking.
Okay. What I think I'm going to do is I have to go back to my office in the central courthouse. I have to edit this a little bit. I'll add in those instructions. If you guys can wait here, we'll get you a clean copy by noon. Review that copy over the weekend, make sure there's no other additions, corrections, or mistakes. And then the procedure will be on Monday. When the jury comes in, I'm going to ask if the defendant's ready to proceed, and I'm assuming you're going to say that the defense rests. And when that happens, we'll hand out the final instructions, and I'll read the final instructions, and we'll go right into the closing arguments.
Your Honor, then I'd asked defense previously, there are officers who are under subpoena still, that they be released at this point.
That's fine, Your Honor.
All right. And well, anyone at this point can be released from your subpoenas. Is that correct?
That's correct.
Okay. I'm just trying to decide the best start time. I'm thinking read the instructions at about 11, break for lunch, and go into the openings early at 1, or you can start and have it broken up by lunch.
I would prefer the court's option of reading the instructions, going for an early lunch, and then not having my
All right.
closing.
I'll have my staff contact the jury and tell them to report at 11. And then we'll still meet here at 10:30, make sure everything's good on the instructions and the defendant's intentions to rest. And then I'll read the instructions before lunch. That may mean we break a few minutes early for lunch, but we'll have them come back at 1 and go into the closing arguments. All right, while we're here, I'm going to call the other case as well, CR 2022-001242. And the state is here, the defendant's here. I'm going to go ahead and set the official trial date to begin May 30th at 9:30 a.m. Actually, 10 a.m., May 30th at 10 a.m.
Your Honor, are we still meeting though the 29th to do strikes?
Yes, I'm going to get to that. I will set a final trial management conference to discuss the remote questionnaire and confirm we're all good to go for the second trial. For May 14 at 10 a.m.
And Your Honor, I will say okay for now. Obviously, we don't have the victim here and we didn't notify him of this hearing. So if that does not work for him, then I will ask to move that.
All right, for now, we're setting the final trial management conference May 14 at 10 a.m. At that time, we'll discuss modifications, if any, to the previous questionnaire. We'll discuss the exact timing of that questionnaire going out, but it'll go out probably May 21st and end sometime on May 26th or 27th, because the 26th is a holiday. And then we will meet on May 29th to go over those responses that the remote questionnaire produces. I'm going to set that for 1 p.m. on May 29th.
Your Honor, I received a notice from the state this morning actually about notice of 404B information for that trial. So are we going to set a 404B hearing for that as well? Would that be at the same time, or do you want to do that at a different time?
Let's discuss that on the 14th.
Okay.
I did see that come in as well a couple days ago. So the anticipated schedule for trial, let me confirm with the state. You think the second trial is similar in length to this trial?
I believe so.
So my proposed trial schedule that we talked about is going to be June 2nd, Monday through Friday, June 6th. We'll shore up those hours and where we're going to be physically located, because I don't know if we're going to be in the same courtroom or not. But tentative schedule, June 2nd through 6th, Monday through Friday, June 9th through 13th. Depending on how far we get, I may cancel that Friday the 13th, but I'll let you know at the start of the 9th or the 10th. And then I have to be dark the 16th through the 20th. And if we need June 23rd through 25th, I think that should be enough time. So that's what I'm going to screen through is those dates for the remote questionnaire.
Not the next June, you said June 23rd through the 26th, but not the 30th through the 3rd?
Yeah, and here's why I'm thinking that is you completed the state's case in this case in
It'll be
7 trial days, 7.5 trial days, 8 trial days. And the 2nd through the 12th is already going to be 9 trial days. And then if something goes wrong, we still have the 23rd, 24th, and 25th. So that's going to be 12 trial days. And some of those trial days I can make longer depending on everyone's schedule. We might be able to start earlier.
All right. The state will ask that we screen them through July 3rd. I just think there is always things that happen, and I would much rather have a jury prepared to stay longer and have them end late than have a jury angry at us because we told them that they would be done on the 25th and something happens and they are not done on that date, or they're deliberating later. So I would ask they be screened through July 3rd.
That would give us over twice as many trial days as we had in this trial.
We had screened these through the 15th, I thought, of June. So
What's that?
didn't we screen these jurors through the 15th of June? So
No, May.
May.
I'm sorry, of May. So
We screened for 6 weeks and we did it in 2.
I understand, but I guess I don't see that as twice as long as this screening.
We had 21 trial days scheduled in this first trial, and you did it in 7.
We had 28 days scheduled in the other one. In any case, that's all I'm asking, Your Honor. You can do as you wish. That's my proposal.
We can confirm it on the May 14th when we meet at the FTMC. I'm open to it. My hesitation is if we go all the way into the 3rd, I think we're going to run into losing a bunch of jurors who are going to go out of town for 4th of July, and they might be leaving on the 2nd or the 3rd. And I think we're going to lose a lot of jurors just based on that holiday where people go out of town. With that said, the current last day is May 11 on that trial. So as defendant want to make a record, because I am going to exclude time. I know you object to the exclusion of time.
I object to not having it by May 11th. Correct.
You want to?
What?
Do you have anything further than that?
No, just that, yes, that I would like to have my speedy trial by May 11th.
All right. Well, we screened the first trial through May 15th. You can't do, and the state can't do, and I can't do 2 trials at the same time. Additionally, the state indicated they need to make arrangements for out-of-state witnesses to come well in advance of the trial. There's scheduling issues for myself. I'm out part of the week of May 19th. I'm out and coming back early the week of May 26th to do jury selection. Additionally, I guess the delay is of minimal prejudice given the current sentences that you're serving. For all those reasons, the court will exclude time from May 11th. The new last day will be June 30th. All right, let me get these jury instructions, an up-to-date draft for everyone. Please stick around. I'll have my staff drop that off hopefully in the next 15 to 20 minutes. And then again, when you review those over the weekend, please alert staff through your advisory council or your paralegal if there's an issue, because we're gonna have those all printed out Monday morning if we don't hear from anyone by about 10 a.m. Again, we'll ask my staff to contact the jurors and have the jurors report for 11 a.m. on Monday.
And Judge, is the court able to just email those to me, or do you want me to stay here and wait to get a hard copy?
I will email them to you and advisory council and the paralegal, but if you want, you want a copy?
I'll wait for a hard copy.
Yeah, I'll print out a hard copy for the defendant to take with her here today.
Thank you. Thank you, Your Honor.
All right. Are you signed up for that? Okay. All right, thank you.
All right. I think that is going to be it for today's proceedings. We learned when Brandon Boudreau's trial is going to start. It's going to overlap with Donna Adelson's trial. A couple of quick things. Just by a show and chat, would you like us to take FSU is holding a news conference at 4 p.m. Eastern. That is in 46 minutes. Would you like us to cover that? Please let us know. Tim Jansen and I have been kind of texting back and forth. I assume it's going to be the Tallahassee PD along with the FSU police force. Right now, it looks like 6 were injured, 1 dead, and someone in custody. There's still no all clear. Ned Smith saying yes, please. Vesper saying yes. If we're going to do that, I'm going to jump off in a moment. Let me just recap some of this stuff. So today, Lori Vallow confirmed, but not very firmly. She confirmed that she's not going to testify. If she comes in, and the judge brought it up multiple times afterwards. He just brought it up a short time ago. And the bottom line is that Lori says she's not going to testify. The defense is resting, but that does not mean with a person like her on Monday that we won't still hear from her. So you got that. She said her quote was, "Right now, it is as of this morning," meaning that the defense is rested. They finalized jury instructions with Judge Boreski. He pointed out that they were really just standard instructions. Self-defense language was changed from physical force to deadly physical force. There were some disputes and some edits. Lori wanted to add a definition for causation, ignorance of fact. The judge denied it, saying it was not relevant. Jury instructions are going to be read, I believe, at 11 a.m. on Monday. They're going to take a early lunch, and then closing arguments will begin 1 o'clock, which is 4 Eastern. But if it's still on a half-hour delay, it's really 4:30 Eastern, and we will bring that to you live. That will be on Friday. I am predicting a very quick deliberation, although I could very well be wrong. If the verdict comes back Monday, we're going to bring you the verdict whenever it does come back. But certainly, if it comes back Monday, we will bring it to you then. Brandon Boudreaux. Well, one trial's over, the next almost over, the next almost set to begin. The judge announcing May 30th, 10 a.m. I like this judge because I'm a night owl, and he starts everything late. The trial dates are actually physically set June 2nd to the 6th, and then June 19th to the 13th. A break June 16th to the 20th because the judge is away, and they resume if needed. This is the attempted murder of Brandon Boudreaux, who Alex Cox took a shot at while driving. His wife, his ex-wife, is the niece of Lori Vallow, and a lot of people think that Melanice is guilty here as well and should be charged. Myron Sanchez, Miami Myron, he says an hour-long verdict. I have to agree. It's going to be somewhere along those lines. I do think they find her guilty, and I think they find her guilty very quickly because Elaine was just asking. So there'll be a final management conference May 14th. Couple of quick notes about next week, things to look forward to. Well, starting with tomorrow, 12 noon, Phil Ramos, who is a veteran homicide detective, will be back with Dr. Detective Troy Looney, who's an active detective with the Akron, Ohio PD, and they're going to continue. They started breaking down the Stefan Stearns interview, police interview. That, of course, is the man accused of murdering 13-year-old Maddie Soto in Orlando. So the two of them will be here tomorrow, noon Eastern. I've been in the courtroom for the entire trial. It is hard to read some of the jurors, but there are many who have shown their displeasure for Lori. Thank you for that. Nothing quite crafts and true crime, Tracy. Nothing like, I like that, crafts and true crime. There you go. Crafts and true crime. What would I be? I'd be ranting and true crime and ranting. I don't know which order. June 3rd is Donna's jury selection. Most important, my daughter's elementary school graduation is June 5th, so I can't do anything or go anywhere till that is over. Her birthday is June 8th. So I may have to sadly miss that. I don't know. Yeah. Took me a minute, COE. Took me a minute, but I got it. About next week, whining and true crime. That's probably the most accurate and the one that would bring me the most joy. would anyone watch a show called Whining and True Crime? I would like to just rant. By the way, I do think we're not going to do shows on Karen Reed, but you know my FOMO with that. I think what I'm going to do is a daily rant about the trial on video, not live. So post videos, it'll be my Karen Reed daily rant. I'll whine while you whine. What's my beef with Karen Reed? That'll be sort of the overarching. What's my beef? Not where's the beef, but what's my beef? Just came up with it. Space Coast says, please don't. I'm definitely doing it. What do you guys think of that idea? Should I rant every day about something related to the Karen Reed trial? It will not be live, Vesper. It'll be video because I promise people that I will not cover it live because they want an alternative, a Karen Reed alternative. Joel, you do rant, LOL. I do this to the COE at night. I will just rant to her. That's how I came up with this idea. At first, I wanted to do some sort of media angle, but instead, I think I'm just going to rant. What's my beef? This will be the Karen Reed trial. And trust me, I will find something every day that is irritating me, and I will whine and rant about it. Moving along here. By the way, I was told that, and I'm honored by this, that a rant emoji was created for me, and I'm unable to see it on StreamYard, so I guess that would involve me having to go watch my show after the fact, but I am truly humbled and honored that I've been given a rant emoji. Joel, do you need a Tylee correspondent for the Adelsons? I'll be there, but you're gonna yeah, I think so. Haas Long. That's a good title, Dreamscape. That's a good title. Anyway, about next week, I did speak with the father of Rachel Morin's husband. For those who don't know, she's a 37-year-old mother of 5 who was murdered on the Ma and Pa hiking trail in Maryland. Her killer, who happens to be an illegal alien here in the country from El Salvador, he was just convicted last Friday. And Matt McMahon, the father of Rachel Morin's oldest child, and her half sister Erin are going to come on the show next week. Originally, it was going to be Monday, but it looks like we're going to get Lori Vallow. So we'll slide it, but they'll be here next week to talk about the experience of going through that trial. Rachel's mother has been all over the news, but we'll get the father of Rachel's oldest child, Faye, and Erin, who is her half sister. We also next week will try to pick up the Grant Solomon story. That's the one where he died under suspicious circumstances. I believe he was 18. He was this phenomenal baseball player, all around good guy. Allegedly, because he was going to out his own father about some SA allegations against his daughter, against the father's daughter, Grant's sister. And now the mother has just been arrested when, Ned Smith, she's like, you've arrived when you get a rant emoji. It is, I don't think you can get better than that. Anyway, we're going to try to do Grant Solomon, the mother, now arrested in a murder for hire plot with undercover agents trying to kill Grant Solomon's biological father, who happens to be a former news anchor in Nashville. Also, there's news with the Alexander brothers. They are back in the news because Tal Alexander, they're the 3 brothers with more than 60 accusers, accusing them of the most horrific types of crimes. Well, Tal, the oldest brother, was served divorce papers by his soon-to-be ex-wife, Ariel, and now Tal Alexander says he is the victim, and the divorce, and I quote here, will be a war. He's saying this from MDC Brooklyn. If I was in MDC Brooklyn, I'd be like, have fun. Yeah, I think we're going to do the presser, which means I have to jump in a second. Leave the live and take I love how I have like 17 Jewish mothers here all of a sudden. Leave the live, just take a half-hour break, come back. I will do that, Vesper. And last but not least, for next week, I want to try. Wendy Adelson was on a podcast The COE hopefully can pull chunks of that sound from that, and we can do that as well. Next week, there is a lot going on, and it's going to get a lot crazier because Stephon Stern's trial is early May, Donna Adelson's early June, Brian Koberger late July, and we'll be at all three of those. So, COE, I need you because I don't know what to do here. COE, are you there?
Hi, yeah. Didn't court end?
Court ended. I think people would like us to take the
We're gonna end the stream and start a new show.
sounds good. We'll see everybody at 4 o'clock then.
Thank you.
Thank you for being here. We have amazing communication here at STS, the best communication, which is me sitting in a studio in an undisclosed area atop a Bank of America in Miami Beach, getting absolutely no guidance from anyone. That is our communication. I cannot wait for the Karen Reed rant. I'm going to rant. I'm going to love it. Yes, Vesper, you are now elevated to a booby. Yeah, right here. That's how you spell it too. Joel, you are lost with the COE. I think you meant without the COE here, Rosie. But either way, I'm lost. The COE says I will get the link up in 5 minutes. I'm going to go call Tim Jansen. Love you, America. Love you, Maricopa County. Love you, everyone overseas. Love you, everyone in America. Love you, everyone in Canada, Australia, Ohio. Love you, Ohio. And justice for Charles Vallow. What just happened to my thing here? Hang on. Justice for Charles Vallow. See you guys in a half hour on the FSU case and then the Menendez brothers after that.